going to call this meeting to order, and we have a small two-person ad hoc committee today. Hello, Mr. Richmond. And thank you everyone for joining us. We need a motion to adopt the agenda.
So moved.
Okay, and I'll second that. And we are all in favor, correct? Okay.
Yes.
The agenda is adopted. Mr. Richmond, did you have a chance to review the meeting minutes? I had a chance to look at those.
I did. I looked at them earlier.
Okay. Did you have any changes or anything?
No, none that I was able to see.
Okay, great. Yep. I also thought those looked good. So if we could get a motion to approve those.
So moved.
And I'll second. And all in favor? Aye.
Aye.
Great. Okay. Moving right along. We're halfway through our items. Okay, the next two are the big ones. Okay, so there are essentially two documents that we are going to review today. One is this role scope overview document, and the other is the policy. And basically, each of these, in the last meeting, we decided that we were going to ground our descriptions in the Pasadena materials and the Loudoun County materials. And so what's happened is Neil and I have worked through from a legal perspective, and just some of our discussion, putting those together into a couple of documents we can work from. And the idea is that we will review those today, talk about the next level of decisions, recommendations we need to make, and what the next steps are. So that, and talk about bringing this to the board after that. So I think actually, Franklin, the best thing to do, there are the 4 versions that are on the next agenda item, draft policy. We can look at the role scope overview first. Unless, Neil, do you think it would be better to look at the other one first? I'm not sure what's going to be sort of most logical. Your preference?
Oops. Sorry, I think the overview document is more straightforward, and I love your edits, and so if you want to start there, that's a little simpler.
Okay, cool. So, but I think, Franklin, if you could go down, because I think the version that Neil sent back of the overview has a little bit from him maybe too. So if you could open, we can do the red line version. There's a clean version of each too. But essentially this document, let me see, I'm going to make my screen a little bit bigger, but yeah, thanks for zooming in. That's great. Okay, so essentially what I did was I took the contents, Franklin sort of pulled the contents of that Pasadena document into a document that we could work with. And then so where you see the red line or blue lines are the places where we've edited what was in the Pasadena version, right? So first is, and the point of this overview is, we can pull from this just to create a job description if it becomes a role, or if we are doing sort of a scope of work thing, looking for a consultant, we could use it for that. It's just sort of similar content for either one of those. So it starts with the purpose section. So you'll see we took out the other community groups since we decided this would just be focused on employees. And then there's some places where it's at Ombud's office and now it just says Ombuds, and it referenced the other district and we took that out. And rather than saying you can contact them if, because that was for a brochure, we put, here's when somebody would contact. So it's kind of straightforward. And then if you can keep scrolling down, Franklin, there are the guiding principles that we looked at. And there's an opening line, which is taken from the Loudoun policy that just kind of framed those guiding principles. The ombuds will operate under these guiding principles. They're the same ones that we looked at in our last meeting. And then if you can keep scrolling down, the scope of work / responsibilities, this is the section of the brochure, if you remember, that said what the ombudsman will do, right? And so the only change that I had there was we had talked about, Will had suggested the services and programs, sort of putting that first to make sure that it's clear that people can point people to different programs rather than just policies and procedures. So I changed that. I didn't have anything else in that section, Andre, that I thought we needed to fully change a bullet point or anything. At the very end, I have the what they will not do section. That's kind of at the end of this document, but was there anything else?
No, nothing else that once I looked through it, I didn't see anything else either.
Okay, great. All right. So then this section is qualifications, and I think we should talk about this. This is, I took this from like an existing ombuds job description, and like edited a little bit, because I think that was maybe for a college setting or something. But
Mhm.
I don't know. Have you had a chance to look through this already? I'm curious. We can just take time to, I won't read it through, but if you want to just read through this now, I'm curious if anyone, Dr. Merrill, Neil, Andre, anybody has other things they would say in terms of the what we would be looking for, either if hiring or looking for somebody external.
Sarah, just to break the silence, I don't really, there's not any legal rules here. This looks fine to me. You know, I don't see any legal issues with it. It's just up to you all as a board and you know, if Dr. Merrill has thoughts as to whether you want more or less experience, how wide a net you want to cast, what's required or what's recommended, you know. But you could also post with requirements, and then if you don't get enough interest, you could relax the requirements and make you know, years of experience, you know, preferred but not required, for example.
Yep. Yep. The one thing I had been thinking about that I think will be important, and this was prompted for me reading the policy, Neil, was in the preferred, we have like past experiences, K-12 ombuds strongly preferred. I think that would be great to have the K-12 experience, but even any, because of the records require, you know, the public records stuff in public, you know, governments, I do think that somebody having already had experience with that would be really valuable for them to have good judgment about what to record, what not to record, and how to navigate that. So it does already say sort of strongly preferred, but
Yeah, I agree, because that's I think that's very, very valuable, and that's going to be key to this position, because like you said, we're going to be, I mean, they're going to be dealing with a lot of information, personnel information, and being able to be being able to, you know, kind of keep that information to themselves and whatever shared with them to themselves. So I think having that experience is going to be what's needed position.
Yeah, I agree. I didn't want to put required because I was concerned that that would, if, you know, if we changed it to like, you must have had experience as a K-12 ombuds, that really limits the pool. But essentially, if someone does not have that experience, I think the amount of time they might need to consult with Neil, or, you know, just the amount of training they might require or something might be higher, which would be a concern. So
True. That's true.
A couple thoughts, observations. One is, and maybe it's what Andre was getting at. Can you guys hear me okay?
yes.
Okay.
Yes. Yes, sir.
And I don't know whether it's a required, first of all, generally in required, you've got a lot of things here that are really soft, important, but about the only way you can ascertain someone's ability to gain and maintain trust is through referencing or something. Not and so difficult to measure. So so it's bullet one, that's quantifiable. The rest are pretty much, we got to do some digging. All that being said, what I heard you recently talking about is maybe there's something that says ability to understand, or ability to, and I've not written anything, ability to support and assist people while still maintaining required confidentialities, or something like that, because there's a fine line, and they need to be able to walk both. So that's just a thought. The other thing under preferred, so your first two bullets are redundant because you end with the word preferred, and this is just technical. But when I read the third bullet, well, then maybe it isn't quite as important because you didn't say preferred after it. So I just say parallel structure one way or the other, which I hate to be that technical, but it jumped. I'm reading it from someone who's reading it and going, okay, well, knowledge is K-12 is nice, but maybe not as strongly preferred as these others. So
yeah, I actually was trying to distinguish between the things that were strongly preferred, the first two, and like we prefer. So I think somebody who has past experience as a K-12 ombuds person should really, I mean, that's a real strong plus, but beyond that, understanding of how K-12 works is also preferred over not.
Yeah,
But, it might be that we think, having some knowledge about the working environment of K-12 is a requirement and the other two are preferred, I don't know what you think about that.
But to Dr. Merrill's point, the only hard requirement you have on the first list is 3 or more years of experiences in ombuds in conflict resolution or mediation or similarly relevant field.
Yeah.
And track record. So I would imagine, outside of ombuds, you maybe hopefully you get some actual ombuds with ombuds experience. Other than that, you probably get attorneys or people who've done mediation work or arbitration work in various contexts. Probably, I would guess, a fair number of lawyers would be in the in the category. So so just not clear how much education is experience and understanding is important, and whether you want to elevate that to a requirement.
Yeah, there's in the required section is knowledge of the sort of ethical codes and standards of the Ombuds Association. So that's sort of a basic knowledge piece. I think we could pull the knowledge of K-12 up there. I'm personally inclined to think the skill at the interpersonal side and the judgment and those kinds of things are more important actually than whether you really understand how school employee experience is in terms of effectiveness. But we could also put in the required some sort of knowledge of public records. I don't know how important that is to North Carolina.
It'd be a plus, but I mean, we do have in the policy that the ombuds would have access to legal counsel.
Yeah.
And so you wouldn't, unless they are already a licensed North Carolina attorney, you wouldn't want to make their own calls on public records.
Yeah. Okay. So we shouldn't include that then, I guess. Well, how about, what if we, in the preferred, we took out the words strongly preferred in those two places and just got rid of the third bullet? What do y'all think about that?
I'm fine with that.
Start with that. We're bringing this to the full board as well. So we could potentially do that. And your point is taken, Dr. Merrill, about the sort of less hard skills in the requirements. I didn't want to put anything about a particular type of degree or anything like that, because that can really cut some people out. But I think a lot of this we'd have to get through some sort of interview and reference check.
Yeah, I was just observing, not being critical of it. It's harder to assess this. That's all.
It sure is. Yeah, you're right. Okay, so do the number of years of experience here look right? And the things that are in required versus preferred? Andre or Dr. Merrill have any?
I like the fact that having 3 or more years. Usually I'd say two or more, but 3 or more, that's totally fine with me.
Mm-hmm.
And as far as the preferred bullets go, like you said, removing the knowledge of K through 12 public education and the working environment K through 12, we can just keep the top bullets, shorten that, and then we can add that in, like you said, to the requirements.
Okay, so you'd prefer to have that knowledge, some kind of a knowledge there in the required section?
Yes.
Okay. And then, all right, so let's do that. And then Franklin, if you're taking notes here, right? So can we also take out the strongly preferred? They're just, those are two things that are preferred. I think that.
If I can go back to your first required bullet, and it's the English teacher in me, I guess, but so the 3 or more years
Mhm.
is concrete.
Mhm.
Everything else allows for flexibility.
Mhm.
When you go, or similarly relevant, that opens the door for judgment to say, okay, well, this is related. Could there be a situation where you would want the flexibility on the 3 years? What if you got a superstar who's knocked it out of the park in DC for 2 years? For instance,
Yeah.
I just don't want you painted into a box if somebody incredible comes by.
Yeah. I guess I wouldn't want to say 1 year, 2 years
No.
of superstar, maybe, that maybe we should say 2 or more years there. I'd be inclined, the person with more experience is going to have been through more experiences and have better judgment as a result, but I could see 2 or more years potentially.
Yeah, I like the wording of 2 or more. I just look at my profession, and I know usually when someone has at least 2 years, then we kind of consider them somewhat able to go out and train other officers. So that's just what I base my my vision on, was 2 or more years. So
Well, what I was also, and I didn't have the solution, leaving 3, but coming up with some other language that addresses 3 years in a way that you can say similarly relevant field, or comparable experience, 3 or more years, or comparable experience as, and then we're free to define what comparable experience would be. That then you've left it open for flexibility. I don't know, I don't want to belabor anything here, but.
Sure. No, okay. So let's say 3 or more years or comparable experience of comparable experience. Just want to clarify what you mean there.
I guess you could also have flexibility as between years of experience. So you could, for example, say required 2 or more years of experience as an ombudsman or 2 or more years, 3 or more years in conflict resolution, mediation, or similar experience in a comparable field. So you're upping the requirement if you haven't actually been an ombuds before.
Yes, I really like that distinction. Franklin, did you get that? So it's 2 or more years of experience as an ombuds person, or 3 or more years of experience in a relevant field, such as conflict resolution or mediation.
Yep.
And then I would maybe take the demonstrated track record of success and make it its own separate bullet from that, just so it's like a little bit clearer.
Got it.
Okay. Any other thoughts on the qualification section? All righty. Okay. So the next piece is, I just called it cost and logistics, because we're deciding whether to do in-house or contracted. And so we're going to need to figure out what would be the potential cost of either of those routes. And then Franklin, if you could scroll down a bit more, the other things there are like how much will they be working? Is it a 12-month role, work hours? What's their schedule? If it is in-house, we're going to need to know what their FLSA is, and then where work location and who do they report to. I believe the reports to, we aligned on co-reporting to the board and superintendent. But am I remembering that correctly? I'm seeing 2 nods.
That's what I did in the policy. And, but it's really up to you all and subject to discussion. My thinking was, the board meets twice a month. The board can't do hands-on management. Really, that's just not what governing boards are designed to do. So if there are questions that come up and the ombuds need some direction or authorization from somebody with some authority, I think having the superintendent in the loop is going to be pretty essential unless you want to be prepared to have a lot of special meetings anytime the ombuds needs to run something by the board.
I don't think that's our
So
intent.
I designed it that way. And also, I think we used the language that was in the model policy that we based on, which was for budgetary and evaluative purposes. The superintendent has some authority, but the whole idea is the ombuds is sort of otherwise outside the chain of command and is independent, similar to, I guess, like the Fed chair in the federal government or something. The president has some direct authority, but really the Fed is operating separately. And I think the ombuds, that's the idea too. The ombuds talking to employees confidentially, not necessarily, in fact, not reporting the substance of those conversations to the superintendent or the board.
Right.
But in terms of is the ombuds doing a good job? Who's going to do a performance evaluation? How much money will be budgeted for the office, for support staff, et cetera? Those are all questions that both the board and the superintendent would have some say over.
Yeah, I liked how you put that in the policy, and we can look at that in a minute too. The way the speaking to the like outside of the chain of command, but like tactically speaking, like you do need them reporting somewhere, Yeah.
And that's what this is all subject to discussion. I'm not telling you that's the right way to do it. That's just sort of what we saw in the model policy that everyone liked and wanted as a starting point. It makes sense to me, but it could be done differently. I do remember Bonnie had suggested, I think her comments at a board meeting where she would foresee the ombuds reporting directly and only to the board, and not. I think she had made comments to that effect. Just thinking that through. I'm not sure logistically how feasible that is, but it's subject to your discussion and recommendation to the full board.
I personally would rather for the ombudsman or the ombud person to report directly to the superintendent. I just think it's better that way. And like you said earlier, Neil, as far as valuation goes too, then it's left to the superintendent as well. So kind of removes the board from having to directly speak with that person and then that person feel like they have to do something because of what the board said. So, or a board member may say.
Exactly. And then I'm maybe jumping a little ahead since this is in the policy, but the other thought is if it's not yet settled whether this person would be an independent contractor or an employee, but if it's an employee, then by statute, only you can dismiss or demote only upon recommendation of the superintendent, so that we can't avoid the superintendent having a role in managing personnel. That's essential, and we would have to revise multiple other board policies to do that as well. So if it's your employee, I think the ombuds would have to report to the superintendent, at least to some extent, in terms of evaluations and conduct and performance, not as to the day-to-day work of the confidential communications with employees, though.
Yeah, I totally agree with Andre's thought there and Neil's. And I think the only question I have is if it's a contract and we have a contractor, does it make sense for the superintendent to be directly managing that contract, or would it make more sense to like be human capital or something? You know what I mean? I don't really know. I think that might be a bit more of a question for like, just in terms of like managing the contract, the relationship is just a little bit different. So I don't know.
I would assume we would start with our, you have a template service contract that's got a lot of good boilerplate. We would probably use that if it's an independent contractor as the starting point, and then the scope is what we would need to plug in there. And the scope could include details about accountability and reporting. It's all subject to discussion. I think the model policy that we edited contemplated at least an annual report to the board. And I think I included the superintendent as receiving that report too. Not the details, no names, but sort of a summary of the consults that had occurred over the past year. You could require more frequent reporting to the superintendent or board. Certainly you all should be aware what the person's doing and paying them money either as an employee or a contractor. But I think the whole idea of the position is that it's somewhat protected and separate in terms of the day-to-day work of consulting with employees is confidential, and the details of those conversations are not shared.
Yep. Yeah. So maybe in either case, it's reporting to the superintendent from a technical perspective and dual sort of way. On the schedule, work hours, months worked, this came up in the budget meeting again yesterday. I mean, I think I remember from our last meeting that we were talking about part-time. I could not remember if it was like 20 hours, 25 hours. I don't think we talked about 10-month, 12-month employee or anything like that.
Yeah, I feel like if I can remember correctly, I thought it was about 20 hours that we had mentioned at the initial meeting,
Mhm.
part-time, like you said, there.
20 hours a week, right?
Yep.
Okay. So if we're looking at 20 hours a week, I don't know whether it should be a 10 or 12-month employee. Things really slowed down over the summer, but I guess you'd want that access all the time. So I don't, Dr. Merrill, what do you think?
My connectivity keeps coming and going. But so you actually get a lot of turmoil in the summer with reassignments of staff, split positions rather than full-time in one location. So there's a potential for a pretty amount of dust getting kicked up in the summer.
So 20 hours a week, 12-month, something like that.
Probably.
Yeah.
Probably.
Okay. And then I think in terms of that individual's schedule, well, I mean, we could talk to a contractor. I don't quite know how we should think about that. Like, staff are available after work. So probably we'd want some of their time to be in the availability in the afternoons and evenings. You know, as we're talking to contractors, we can ask them how they've done this in the past and their recommendations. But, you know, if we're thinking about those 20 hours a week, I don't know to what extent we need to define this right now, but I know it's a piece we'll need to figure out. Do you all think that'll be important for when we're writing a job description? Or
I think the ability to have flexible hours will be key. And Neil, I'm trying to remember old training, but as I recall, if a contractor has a regular work location on site, they're starting to look like an employee, and then you got FSLA and things kicking in differently. And that may be something down the road just for us to consider the difference between a part-time employee and a contractor.
That would be one, it's a good point. It'd be one factor. There's a common law test for distinguishing independent contractors, employees. It's good, you know, you need to be clear, because independent, the board is not responsible for the wrongdoing of an independent contractor, whereas you are liable for the wrongdoing of your employees. The generalization, but generally speaking. But I would say office space in and of itself won't dictate that. It's fine to say, you know, you can give what's crucial is that that there's not micromanaging of the day-to-day operations. The ombuds, if an independent contractor would have to be similarly to how we as attorneys, I don't just do what I'm told. I'm paid to give you my independent advice and counsel. So as long as the ombuds is exercising some independent discretion, which is the whole nature of the position, I think we can manage that risk.
So for the independent contractor, we'd say up to 20 hours a week, because we only want to be paying the hourly rate, was my understanding, right? So if it's not used, we don't want to pay for it. For staff, we would say 20 hours a week, 12 months. Work location, and then, yeah, the times for a contractor, I guess we'd indicate the need for some afternoon and evening hours and a need to sort of be flexible. And then on the staff side, potentially the same there in terms of which hours of the day they're working and so forth. You definitely want some after school hours. But I don't know that they would necessarily need to be, you know, if they were a Monday through Wednesday, resource or something. I don't know if it's necessary for them to be available all 5 days a week.
I wouldn't see the need in them being available, all throughout the week, but, like Dr. Mera brought up the summertime, definitely that's when you're gonna start seeing a lot of challenges. So, yeah, I mean, a couple of days a week, maybe even closer to the end of the week. So that way, if somebody's had something going on, they can, early on in the week, they can mention it throughout at the end of the week and maybe deal with it at that time, couple of hours in the afternoon, more hours during the daytime. I feel like maybe that's gonna be sufficient. So that way they can make contact with that person, if they're available during a planning period or something like that. So.
Yeah, I mostly just don't want to constrain, whatever functionally ends up being the most effective is what I want to do. Dr. Merrill, do you have a thought?
You envision that this would almost be like a bill per hours consumed, almost like the attorney, and that flexible time, you keep your log, you submit it, and if it means you need to be available at 10 a.m., you will. If it's 6 p.m., you will. And then there's a hotline or something that the person maintains and then sets their own schedule based on demand and customer need. I mean, is that where you?
Yeah, on the independent contractor, I think so, right?
Okay.
And so, yes, but for the employee, I think we'd need to decide, like, do you want to say right now in the job description, this role is, noon to 5, 4 days a week, or do you want to have a little bit more flexibility there and say it's a certain number of hours a week, including afternoons, and then you work out the exact work schedule that seems like it fits when people need to access the resource.
I think you'll need the flexibility based on the candidate also, perhaps. But there could be times when someone is not going to want to be anywhere near an Orange County facility. And this person's going to need to meet in a coffee shop in Burlington or something. And so highly flexible, conceivably, to be responsive to an individual's concerns or something.
Yeah.
And if they're pegged to an office in the central office, it's like, no way I'm going down there. I mean, for instance.
Yeah. I mean, I even think, if we do go, well, I mean, maybe in either case, like, to me, the work location could be flexible. Like, I think it's going to be challenging to get candidates for this part-time type of, whether it's a contract or in either case. And if the person is in, I don't know, South Carolina, but they have an accessible phone line, where some people can call them, if they're good at that job, that's more important to me than them being in Orange County, North Carolina. I don't know. That's just, if it gets us somebody who's a qualified ombuds, that to me is more important than the meeting in person. But
one quick thought on the office hours issue too. If there are going to be set office hours, whether an independent contractor or an employee, you wouldn't want to pay someone to be sitting around waiting for the phone to ring. So you might want to think about if that's important, then we would have to have some pile of work that could always be done, some sort of systemic review or something so you're getting some value. Otherwise, I could imagine it could be, hey, you can come see the ombuds between 4 and 6 on a Friday, and they sit there doing nothing from 4 to 6. That's not a good use of your taxpayers' funds.
Agreed. Okay. So the question about this is we need to figure out how to price each of these options of having the part-time employee versus the independent contractor rolling hours up to a certain amount. Would Ms. Hatcher be the best person to help us with given this information to sort of benchmark the salary for this?
I think so, between Joyce and Rhonda, I think the two of them could look at. And as long as there's enough of a job description, they could probably figure a reasonable place to start.
Okay.
I-
In terms of,
yeah.
Go ahead.
No, that's it.
In terms of the independent contractors, I have like a few websites that have like databases of people who do this, and you can filter by, K-12 experience or whatever. I'm not sure whether it's best. I mean, I'm happy to reach out to people or to have Joyce reach out to people, but I'm happy to have anybody reach out to folks. And I think just find out kind of what their rates are and how they do this. Having a few conversations would be a good idea. I think we decided we wanted to be able to have those price comparisons and a recommendation from the committee before we bring it to the board.
If you're comfortable, and Andre, I would love for you to dig it. You can go faster, I think, probably than us.
And why add one more thing to the team that's like trying to hire us up and everything. So, yep. I mean, I'm happy to do that. I'm happy to do that. I'll share with you all these, the websites I've found that have these like kind of databases of people who do this, and I'll reach out to some people if that's fine with you, Andre.
Yeah, sure. That's perfectly fine. Yeah.
All right, so I will take that as a next step for me. And then Dr. Merrill, is there enough here you think that we could pass this over to Rhonda and Joyce to try to ballpark the comp for this?
Yeah, now you're going to give us a little data to feed into that also? Is that what I heard?
Yes. Do you mean in terms of the independent contractors or the other information here about work hours and that?
Okay, so no, you split. What you were just asking was, if it's an employee, can we give you the framework?
Yes.
You're going to cover the independent contractor side.
Yep.
And
That's
both
fine.
these are about compensation.
Yes.
Okay, yeah, we can do that.
Awesome.
Franklin, I'm going to want your roughed out version of what the job description will look like, so we can work with them.
Was that one of the documents that was added, or we need to create that?
Well, I think it's what we've been talking about.
Yeah, you'd have to create it based on this conversation about work hours and so forth. And then I think the scope of work and the requirements, those are two of the main sections of the job description. So
Got it.
hopefully those will give you the different pieces you need there. All right. Good conversation. Okay, this last section is just what the ombuds will not do, which we saw in that other document from Pasadena before. Just wanted to make sure that was captured somewhere here, but that's not going to go, I think, in a job description. It's just for our own reference. If it's all right, then let's move over to the policy. And the red line version of that, I think it's the upper, there you go. And I didn't touch this one. This is all Neil bringing in North Carolina law and converting some of the language to us.
And in a few cases, it just needs sort of freelancing a little bit. I'll try to flag those as we go through. But for the most part, yes, I do. I tried to just think about North Carolina law and your policies and make sure that we weren't running any conflicts there. That was the main goal.
Yep. So, this isn't the policy committee. So I think what we'll do here, but this does lay out like all these questions people will have about like, how would X work? How would Y work? And so this is mostly just to like be able to bring this for the policy committee to finalize once we have the other discussion with the board about the position in the first place. Maybe we can scroll and just quickly look at spots, Neil, where you added something a little bit more substantive.
Sure, if we can just scroll slowly, let's pause there. Let me take a look. So on this page, I did add, I thought it was important to say that ombuds will follow the Ombuds Code of Ethics, but to the extent there may be any conflict between those policies and your policies or state law, your policies prevail. So that's the point of that edit. These are just not a lot of you'll see a lot of strike through that's just changing LCPS to OCS. It's a different school district. All right, so let's go down. Can we go back up a little bit, Franklin? Yeah, I just want to see that first paragraph. Yeah, so this model policy had the chief of staff had an active role, and I've changed that to say the board and its sole discretion. Can we scroll down now? Shall determine funding and resources after considering recommendations of the superintendent. So that's an example of budgetary control. If the ombuds needs a new computer or wants office support or whatever, then that would go through the normal process that the superintendent makes a recommendation to the board decides whether to provide the additional funding. Yeah, and then that section that we just scrolled past also said that the ombuds could be either an independent contractor or an employee. So that way we have the flexibility. If you figure that out before we get through policy committee, we can adjust that, but that gives you either option.
Mhm.
Okay, go ahead and scroll down. Let's see. So sort of cleanup changes for the most part. I noticed in the discussion about the overview document, Sarah, that you noted that you removed references to the office of the ombuds. I have not done so here. This policy describes an office, and so I've kept those references. Made some changes.
That's fine. Yeah, the other one is like more like who's this person we're looking for, and this is more like we have an office.
That's true. That's true. So in the office could be one person, the ombuds.
Right.
But it's just not, I wasn't sure of that, and this policy referenced the office, so I left in those references. So it doesn't require you to have other staff, but it's possible. It references the possibility of other staff. This in section C in protection from retaliation is just a rework of what they already had, but basically it says and this is just important to keep in mind, that to protect the ombuds, the ombuds can not be reassigned or demoted except by the board. So normally, and that would be an exception to the normal rule. So under state law, you cannot dismiss any employee except by the recommendation of the superintendent and approval by the board. What we have here, again, it's just subject to discussion. Doesn't have to be this way, but understanding the concern about protecting the ombuds, from fear of retaliation, and the superintendent, in theory, is the person who has the most power in the district. So there's a little the idea that build in a little insulation there is that while the superintendent could normally reassign the duties of staff without board approval, because the board has delegated that authority, that would not apply to the ombuds. The superintendent cannot say, ombuds, I'm putting you in a TA, in a teacher assistant role, paying you your ombud salary for the rest of the year. You're done as ombuds, not without the board approving it.
Yeah, that totally makes sense to me. And I like that you have the last sentence that the superintendent can give recommendations as well, because if we're unhappy with the service provider, like the board would want to be able to hear that. And,
exactly.
Yeah.
Exactly. And this would apply whether it's an independent contractor or an employee.
Mm-hmm.
So that there would be a slight difference from the normal protocols if it's an in-house employee, but the superintendent would still be able to recommend dismissal, recommend reducing hours, advise the board about performance issues that he's observed, et cetera, but would not be able to unilaterally dismiss an employee or demote or reassign.
That makes sense.
Okay. So then if we can scroll down a little more, standards. I didn't do much, I don't think, in this section. Let me see. Maybe. Yeah, here's the reference to the annual report. These are mostly just clarifying changes and updates, not substantive. Let's see, in section A.
I personally like to get a report more than annually, like
Could certainly do that.
at least in the beginning, especially in the beginning, but I don't know if twice a year, or I don't know what the right cadence is. Andre, what do you think? But I don't think annual is quite frequent enough.
No, I don't think so either. Yeah, I would say at least twice a year.
Mid-year report and end-of-year report.
Right, mid-year and end of year. Yep.
You all want to go ahead and update that to say twice a year or quarterly or something?
I don't, there you go, Neil. See, I don't think it's unreasonable to start off quarterly.
Okay, let's do quarterly.
I mean, you need to see how this thing's working, and you don't want to
Right.
wait 7 months because you got to get 6 before you shut it off, and then you do your data summary.
Yeah.
You can always back off, modify after if it's running really well, but
I think that's a great point. All right.
Yeah. Yeah.
So let's shift that to quarterly.
Let me take a quick look at subsection A here, see if there's anything to flag. Okay, yeah, this is an important section on disclosure. This is the kind of the core of the confidentiality section. And so basically I preserved the idea in the model policy here that the ombuds can they said violate confidentiality. I didn't like the violate word, so I rephrased it, but can disclose the contents of what would otherwise be confidential communications and I just rephrased it slightly for clarity to say that if the ombuds reasonably believes that such disclosure is necessary to prevent or mitigate an imminent risk of serious harm to any person, someone's about to get hurt. I'm concerned this is going to, we don't want the ombuds to not make a report to law enforcement or warn a person that someone might be coming to get them. So that's the idea there, and I think that's reasonable. It would be important, obviously, to disclose that on the front end, and this policy that we started with contemplates that the person who goes to see the ombuds will sign something, indicating they understand the confidentiality limitations. And then beyond that, I think we can scroll down now. Oh yeah, there's also, I preserved their idea about reporting child abuse and neglect reporting, because that's a mandatory report under state law. So I think the basic idea here is if the consultation involves disclosure of suspected or known child abuse or neglect, the ombuds is to tell that person, direct that person to the proper reporting mechanisms per your existing board policy on child abuse and neglect. And if that person does not follow that protocol, the ombuds himself or herself would report it, because we can't risk failing to make a mandatory report to the CPS. And then if you scroll to the next page, Franklin, there's I did add, I think might be, there's some formatting issues here, so we can just scroll ahead a little to the next page here. Broken off here. Just keep scrolling to the next page.
Hey Neil, quick question for you.
Certainly.
Do you think we need to include the general statute with that?
Like put the statutory reference
Yes.
reporting. We could
Just a numerical general statute, so that way they can have something to,
Yeah, I probably I think, but I'm not sure. I've referenced the specific board policy on CPS reporting, and that policy has a statutory reference. We could also include it in the statutory references at the end of this policy.
Okay.
Normally would include statutory references at the end rather than clutter up the policy.
Right.
So people just their eyes glaze over when they start seeing the statutory site. But yeah, we would list it in the references. And then the other, okay, so here's where we got into a little nuance where I had to do some thinking. So under North Carolina Public Records Act, we start with the presumption that all records, including emails and notes that are taken by, or received by, or sent by school system employees are public records. We have a few carve outs, one of which is personnel records. So what I think is reasonable, and I can't tell you this is like 100% bulletproof, but I talked with several colleagues, I think this is reasonable, is that if an employee is contacting the ombuds by email, and it's about concerns about their working conditions, that email is a personnel record of the employee expressing the concerns and is therefore confidential as to them. The ombuds can be permitted to receive that information, but it's confidential. It's not subject to a public records request, right? A FOIA like disclosure. We don't have to provide it to the newspaper reporter or anyone else. Where it gets complicated is, what about the rights of, say the employee is talking to the ombuds about concerns about their supervisor. My supervisor is harassing me, bullying me. I think this may be racial discrimination. Now we run into the possibility that that is a personnel record of the subject of the complaint. And if so, that person would have a right to see it, but that would defeat the confidentiality of the ombuds consult. So where I think it's reasonable to sort of way to resolve this is to say, and this gets into some, tell me if this is too much or too little of a legal explanation, but the definition of personnel file under North Carolina law requires documents to be gathered. The word gathered is in there by the local board and used in connection with performance evaluation, selection, non-selection, and various other personnel actions. So as long as we are clear that any consult with the ombuds will not, those emails, so getting back to the example, the email from the employee to the ombuds, I've got a concern about my supervisor harassing me, I think this may be discrimination, that cannot be used in personnel action against the supervisor. This is purely for the consult with the ombuds. The ombuds' job would be to advise the employee, you can pursue a formal complaint, here's the board policy. At that point, it is a personnel record that at some point the supervisor would have a right to see. But up until that point, it remains confidential because it hasn't been gathered by the board to use as a personnel record of the subject of the complaint. Does that make sense? So it's a little murky under North Carolina law, but I think that's reasonable, and that's the best I could do to really draw a tight circle and protecting the confidentiality of the initial consult with the ombuds.
My only question there is, if it's not a personnel record, then is it FOIA-able?
So it's no, because it would be a personal record of the person who contacted them.
Oh, because they're complaining about their
The
working
concern
conditions.
was, could it be a personnel record of both? And we do deal with this situation sometimes. So like, an employee in an employee grievance about a supervisor, it may be the case that we have to advise that the person's the subject of the grievance, what was the complaint against me? We can't have a secret, you're being reprimanded or demoted or something because of some secret allegation against you. That person would have a right to know who said what about me at some point in the process. But I think we can avoid that here. We need to avoid it here, or it's not an ombuds, right? It's the ombuds can only do ombuds work if that consultation on the front end is confidential. And I think the only way to promise that level of confidentiality is to say this communication will not find its way into the personnel file of the person who's the subject of the complaint. It will not be used as the basis of any action. This is just for you to get some guidance about where can you go, what resources are available, what policies are there for you to pursue a formal complaint. And then if that person doesn't choose to pursue a formal complaint, then, I guess it would end there. It would not get documented in the personnel file of the subject of the concern. Any other questions about this? Is kind of the trickiest part for me in working on grievance policy.
So I'm playing it out a little bit, and this is a rabbit hole. And one that on the front end has to be really well defined for not only the ombuds, but the person calling in.
Mm-hmm.
Because if they would be expecting that something will happen or someone will talk to the person they're complaining about on their behalf, I think you're starting to move away from either protecting the person being claimed against, or not honoring what the board was hoping could occur with this position, if that's making sense. Because if the ombuds person is little more than saying, here's a policy, here's the grievance form, et cetera, good luck, then I don't know that that's all the board wanted out of this. And maybe the board wanted some investigative opportunity or follow-up, but then it's getting into the person being complained against has some right to know who's doing what and what. In other words, how can anybody, if it's reporting to the superintendent, and I'm not getting on a roll, but if it's reporting to the superintendent and the person walks in here and says, got a complaint against the principal, Donna, what are we going to do about it? I don't know that I can go to the principal with that information. And yet somehow I've got to try and deal with that. And so you're asking the employee to go back and do what they should maybe be doing. But the reason they're calling the ombuds is they're afraid anyway. I'm just saying, Neil, that can get really tricky, crossing lines and blowing some confidence and yet still wanting to respond to the concern. Is that making sense or too much of a ramble?
I think I follow you. I mean, it's a difficult line to walk. I think it's a difficult job, which is a good reason to get somebody with ombuds experience. One thing, and this, again, most of what's here was already in the model policy. It's not my, idea. But what this model policy started with is the basic parameters would be the ombuds can do consultation, point people to resources, steer them towards formal grievance policies when appropriate, but also could help try to facilitate informal resolution. But it was clear to me that would all be outside the auspices of formal grievance policies, because those are often track legal requirements and they can lead to appeals. And it's just, it's a different process. So a formal grievance, for example, for racial discrimination or bullying or harassment, you've got a policy on that that's based on the school board's model, and it's a 3-step appeal process, and the investigators are defined in the policy. It depends what type of complaint it is. If it's a parent complaining about, discrimination against a student by another student, the principal's the investigator. If it's an allegation against a staff member, human resources investigate. So we've got all these details for formal complaints. And I think as I understood this model policy, the ombuds would explain all that to the employee who comes with the concern. Here are all your options for formal complaints, investigations. I can't pursue those for you. I'm not an investigator. I don't file a complaint. I'm not an advocate, but here's how you could do it. Here's the policy. Here's who you can talk to for more information. And if they don't want to do that, if they're looking for more informal resolution, then the ombuds could maybe try to facilitate a discussion. This is just two people not getting along. I'm not hearing anything that triggers, a legal claim or racial discrimination or anything. Maybe I can get these people to sit down and talk to each other. Then I think that would be permissible and within the ombuds role. But it can be defined differently, but that's what started with this draft.
I would ask Ms. Smiley and Mr. Richmond, do you think this represents what the board was envisioning for this role?
I think so. Yeah. I think
Okay.
we've landed on the no role in sort of formal processes, but that sort of informal, encouraging that if it doesn't meet that standard, like encouraging them to go to you as a next step. There's the ways we want people to be able to handle things and help. I think it's like, how do you break down that barrier of helping them handle it that way?
Right.
Um,
And I think that's why we added in those other resources too,
mhm.
so that they can kind of redirect if need be.
Mhm. I realize we're 1 minute away from 1 o'clock, and we haven't gotten all the way through this policy. So we should probably decide to set up another meeting where we finish going through this. And then I think we'll have those 2 documents in a pretty good place to bring to the board. And then hopefully in that next meeting, we can also bring the cost estimates of those 2 different models, and sort of figure out if there's one of those we want to recommend to the board, and then talk a little bit about bringing this to the board. I think hopefully we'll be able to have one more meeting here, and we'll have a lot of this worked out, and then be able to bring a recommendation to the board. Does that sound good to everybody?
Yes, ma'am.
All right. Well, Dr. Merrill, can you give us a sense, you don't need to right this second, of how long you think you might need for figuring out sort of the costing of things? And then, we can say a couple of weeks out, we're right before the start of the school year, if you want to wait another week after that for things to get going.
I think 2 weeks is reasonable. And you've got some pretty good momentum here. I'd like to see you keep it going.
Yep.
And I think what we're looking for is doable in our time frame.
Great. All right. And I will get on talking to some independent contractors and trying to get a sense of price and how people do this work. So, all right. Thank you everyone for all of your work. Neil, thank you so much for the deep thought on the policy. That's going to get us so far in figuring out exactly how this person should be operating. So deeply appreciated. Do I have a motion to adjourn?
So move.
All right, I'll second that. We're all in favor.
Yeah.
Aye.
All right.
All right. Thanks, everyone.
Thank you. Thank you.
Neil, can you hang for a minute?
Sure.
This is being
Or-
streamed though, y'all, so just remember that.
Okay, never mind. I'll call you, Neil.
Okay.
Thanks.